This video is an overview of the evictions process in Massachusetts. The most important thing to know about evictions in Massachusetts is a landlord must take you to court if he wants to move you out of your apartment. This is true for all tenants. It is against the law for a landlord to change your locks, intimidate you, or move your things to get you to move out. He must get the court's permission to move you out. If you have a restraining order against you, talk to a lawyer. If you threaten or harm someone you live with, and they get a 209A restraining order against you, you might have to move out sooner. There are 2 steps your landlord must take to evict you. First, your landlord must give you a letter that says he wants you to leave by a certain date. This letter is called a notice to quit. Your tenancy ends on the date in the notice. If you are not out by that date, then the landlord can take you to court. The notice may also list the reasons why the landlord wants you to leave, but it doesn't always. The landlord must prove you got the notice to quit before he can take you to court. Second, the landlord must serve you with a summons and complaint. The summons and complaint is the court paper that tells you the landlord is taking you to court, the date and time of the trial, and the deadline to file for an answer. In Massachusetts, tenants can win eviction cases against their landlord if they prove defenses or claims against the landlord. Defenses are the legal reasons you should not be evicted. For example, if a landlord knew about bad conditions in the apartment and did not fix those problems, then you could have a defense to the eviction. There could be a defense if you prove that the bad conditions existed, the landlord knew about them but didn't fix them, and that you stopped paying your rent after that. There could be a defense even if you stopped paying rent. Counterclaims are your legal claims against your landlord. If you can show that your landlord owes you money, you can use it to lower the amount you owe the landlord. The landlord cannot evict you for non-payment if he owes you more than you owe him. For example, say you find out you are paying for the electricity for the lights in your apartment building's common areas. The electricity for those lights is not your responsibility. You should be able to lower the rent your landlord claims you owe because you paid for the electricity for lights in the common area. Gather proof of anything the landlord did wrong, and when you go to court, use your evidence to prove your story to the judge. One more thing. There are 3 kinds of eviction cases a landlord can bring against a tenant. A case for non-payment, where the landlord says you didn't pay your rent. A fault case, where the landlord says you broke the terms or violated the lease. Or a no-fault case, where the landlord says even though you didn't do anything wrong, he just wants the apartment back. There are different ways to defend against your eviction depending on the type. For more information on when to use defenses and counterclaims, visit masslegalhelp.org/important legal defenses and counterclaims. The information in this video is not legal advice. We're not telling you what you should do. If you have an eviction case, talk to a lawyer. Look for a free legal aid lawyer near you at www.masslegalhelp.org/findlegalaid.